question came up previously regarding the Charter's approach to fees, particularly Section 29.5. The Charter says, in part, voter approval shall be required before any use fee, license fee, or any other fee may be established by the county. And then it continues on to elaborate on that point. So, Mike in particular had been asking about this, and I said we would talk about that in the context of declaratory judgment and what has occurred since the time that that was passed, and that looks like it was in 1986 is when that provision, 29.5, went into the Charter. Well, this is a very interesting area of law and a very interesting question to ponder, and so we're going to try and take it in a pretty step-by-step method and try to, hopefully encapsulate what's occurred here and bring us up to date with what the law is currently within Josephine County regarding fees. So since, the way back, since basically time immemorial, courts have been established to decide questions of law or fact, or both, and to assign relief, as it's called, to one of the parties. So people approach courts and judges just as they always have in past times, to request relief of some kind or another. Oftentimes this involves the court. They want the court to order someone to pay money, or to turn over property, or to do something, or refrain from doing something, and on it goes. The courts these days, and for some time actually, it's not a terribly new concept, but currently what courts are now able to do is provide, in addition to these cases that request specific relief, they can provide a declaratory judgment. So this is a little bit different in that the relief sought is not the traditional kind of, money, property, what the case may be. It's really more getting the court to make a ruling on a question of law. So the courts in Oregon are constitutionally prohibited from providing advisory opinions, but they can provide declaratory judgments. And so there's a real fine line there, but the courts seem to be navigating it. And so we do have this option in Oregon of requesting. Citizens have this too. This isn't just something that counties or governments have, but citizens or parties of any kind can request, corporations I suppose, can request declaratory judgments from courts in Oregon. So what happened in regards to the fees within the Charter played out basically like this. So what I've got here is a file, and this is what I provided to you, that deals with a case that was filed in 2005 that focused on the question of a particular fee that was proposed and approved by the county commissioners, and also asked the court for its opinion and its judgment in regard to the county's approach to fees as of that time. And it's the same approach from 2005 as it is now 10 years later. After the voters passed the amendment that I just read in 1986, the voters subsequently passed in the year 2000 another ballot measure. And I'm just going to take a moment here, if I may, and I'll find that within the file. Oops. Yeah, here we go. We'll have this is going to be the more useful file for me. So the voters passed another ballot measure. And that was, just give me a moment please, here it is. That was measure 1773. So now I'm going to go ahead and read again what the Charter says about fees, and then we're going to talk about what the ballot measure says as well. 29.5 says, voter approval shall be required before any use fee, license fee, or any other fee may be established by the county. So, voter approval came in this form, on this question in the form of the ballot measure, 1773. And the question posed to the voters was, shall all fees charged by the county be based on costs of service and subject to a procedure requiring a hearing? And I'm going to read some more. So within the summary it states this, in part. The county charter requires voter approval before any use fee, license fee, or any other fee may be established by the county. Existing fees or those fees mandated by judicial, state, or federal law do not require voter approval. This is county fees, is what that was saying. And then it says, currently several different procedures are used for increasing fees that already exist. This measure would supersede existing procedures and establish a new and uniform procedure to be followed by all county departments. The procedure would require that all fees, except those provided for by state or federal law, be established or increased only after a public hearing with prior notice. The procedure required that fees be established or increased only to cover actual costs of providing the product or service and administration of the program directly related to such product or service. And then it goes on in the explanatory statement, which I'm just going to read a portion of. It says, the proposed procedure provides that fees for county products, services, licenses, or permits, basically, I'm skipping some pieces, would be by order of the Board of Commissioners. And, you know, I've carved out some of the chaff and just tried to basically tell you what it says. So basically, what we're looking at here is the charter says that voter approval shall be required, and the voters within 1773 approved the procedure for establishing fees. So is that clear what I'm saying there? Okay, so nevertheless, that apparently got challenged by whom I honestly don't know in 2005. And the question came to a head when the clerk, pursuant to a state statute, initiated a fee to, it was the Public Land Corner Preservation Fund. So he established a fee of $10 to be collected for administering the Public Land Corner Preservation Fund. And that apparently drew a challenge, though it did not draw a plaintiff in court, at least not by whomever it was that was arguing about the validity of that fee pursuant to the charter. So, what the commissioners and their legal counsel decided to do in that era was look back at what the law says. And it turns out that in 2003, the Oregon legislature enacted House Bill 2581, which amended Oregon Revised Statute 33710, which expanded the scope of declaratory judgments that could be filed by governments. The new measure did not create a new form of action, but it did allow for governments to basically file for declaratory judgment, ask for declaratory judgment on a whole host of matters that they previously had not been allowed to inquire about. And so, based upon that newly created law, Oregon Revised Statute 33710, the commissioners, and they acted through their legal counsel, the commissioners did file a petition for relief asking the court basically what the law was in this situation. They filed for a declaratory judgment. Remember I was saying that was a different kind of case than the traditional ones that typically get filed. And that's, that's what I provided to you in your packet. So, I'm not going to read the whole thing to you here. I mean, I can, but I think that we would probably lose interest pretty quickly in a lot of the legalese. But I'll just hit some of the high points. So, on 14 July 2005, the legal counsel filed an affidavit, and he stated that he has reviewed the law, ORS 33710 and 720, and that he has the basis then to file a declaratory judgment, because he declares here, and this is a requirement of the law, that there exists a justicable controversy, meaning that the courts have this doctrine that, and it's well-founded in the concept that judges are not supposed to be creating law, they're supposed to be deciding cases. So they have this concept of standing, and part of that is that you could, what they call it is you must have two hands clapping. You can't have a case in which only one person is arguing. See, there have to be two people arguing, or two parties arguing against each other for the court to really get engaged in the question. And they interpret that a variety of different ways, but essentially what they're looking for is, with this question of justicable controversy, are there two people arguing, or rather, or is someone just asking for an advisory opinion, which, as I said, is not allowed pursuant to the Constitution or traditional concepts of jurisprudence. Anyway, so he said that there was a justicable controversy. It sounds like there was a political question playing out at the time that he describes in later court filings. And on that basis, the court did decide to hear the case.
Well, who would the two parties be?
We're getting there. We're getting there. Yeah. I will remember that. But if I don't, you can ask me that again, because we're gonna, like I say, we're gonna try and take this step by step, and then we're getting to that point. Okay. So then he moves the court on 14 July 2005 for an order directing service of notice of summons to all the parties interested in the publication. Now, at this point, the case is called, and the case throughout its entire existence was called as follows, and this I will read in its entirety so that people hear this and know the actuality. It says, so this is what is in the caption. Filed in the Circuit Court of the State of Oregon for Josephine County, in the matter of the petition of Jim Riddle, Dwight F. Ellis, and Jim Raffenberg as the Board of County Commissioners of Josephine County, a political subdivision of the State of Oregon, for a judicial examination and judgment of the court as to the validity of the order of the Board of the County Commissioners establishing fees to be collected for the Public Land Corner Preservation Fund. So that's what it says. That's the caption that heads this case, and filed on the legal counsel's letterhead. And so anyway, he asks for an order directing that he can provide notice to the public, and he does that pursuant to a law. It's ORS 33720, paragraph 2, which basically says file in notify the public through the newspapers. Is kind of how he does it. Just, I'm oversimplifying, but that's basically what he was provided, or what he was supposed to do. And they did. He then files a petition, and the board rather, or it's really the board is the party here, being represented then by counsel. And he says that he wants to determine the validity of the order of the Board of Commissioners to enact an order establishing fees for the benefit of the public lands. And he also asks for the regularity and legality of the actions of the board in so doing. And by doing that, he touches on the larger question of whether the board is in violation of the charter, to sum it up, basically. Or whether this concept of the charter requires voter approval, the voters approve the process, does that stand up in court? So that's what he's asking for by that. And he does even reference specifically by Order 2000-25, the board set a procedure for establishing fees. So, in fact, he says, on May 16, 2000, the board submitted to the voters of the county ballot measure 1773, a uniform procedure for setting fees charged by the county. And that passed. And then he says, by Board Order 2000-25, the board set the procedure for establishing fees to take effect upon approval by the voters. The measure did pass, and the Order 2000-25 became effective by that approval. He provides copies of the measure, and so in that way he's asking the court whether not just this particular fee is lawful, but whether the whole approach to establishing fees is lawful through this declaratory judgment process. Anyway, so they put out the notice and summons. That involved being, the court acknowledged that the notice and summons was served on all parties, meaning the public, in interest by publication of such notice for at least once a week for 3 successive weeks in the newspaper of general circulation published in Josephine County, Oregon. So then, apparently nobody replied. According to the court documents, it would seem that nobody responded to that, or otherwise appeared in court, or otherwise rendered anything official. I don't know if anyone did anything unofficial, but at least in terms of the court, from what the court saw, nothing happened. So he then got to, or the commissioners then got to move, this is a standard thing. If the other hand doesn't really clap, then the court then, if there is a controversy, but the other hand doesn't seem to, for whatever reason, doesn't seem to be interested in fighting it out, then the petitioner then does get to move for an order of entry of default, and that happened. So the board, through then counsel, on 31 August 2005, moved the court for a motion for entry of order of default. Now, remember I said that the caption in the case was in the matter of the petition of Jim Riddle, Dwight Ellis, Jim Raffenberg, right? Well, so nevertheless, getting back to this concept of the two hands clapping and there must be a justiciable controversy, there's another statute that comes to bear here in regards to declaratory judgments. And that is Oregon Revised Statute 28110, which says in part the following. In any proceeding which involves the validity of a municipal charter, ordinance, or franchise, the municipality affected shall be made a party and shall be entitled to be heard, and if the Constitution, statute, charter, ordinance, or franchise is alleged to be unconstitutional, the Attorney General of the state shall also be served with a copy of the proceeding. Forgetting that bit about the Attorney General, we're just going to reiterate the part about the party. So it says, in any proceeding which involves the validity of a municipal charter, ordinance, or franchise, the municipality affected shall be made a party. Well, we're talking about the county here. That's the municipality affected, is a party to the case. And this is touching on, I think, your question earlier on about who the parties were. So the motion for entry of order of default reads as follows. Petitioners hereby move the court for an order of default in the above entitled proceedings against Josephine County, a political subdivision, and all electors, freeholders, taxpayers, and other interested persons, whomever, who have not timely appeared to contest the above captioned proceeding by the filing of an answer to the petition or in any other manner whatsoever. So in that sense, the court was viewing the posture of this case as being the petitioners, meaning Riddle, Ellis, and Raffenberg, against Josephine County, all electors, freeholders, and taxpayers, and other interested persons. So you follow what I'm saying there?
The three commissioners were then going up against the county government and all the population?
No, going up against the county.
Well,
Yeah.
the county government?
Well, the government is part of Josephine County, yes.
Right.
The government is part of Josephine County, yes.
So the commissioners are then opposing the county government and all of the citizens.
It doesn't say county government, but I can follow your rationale there, yeah. Electors, yeah. So,
Really? They're on both sides of the argument.
This is an awkward thing, this kind of a case. So that's,
Now, Wally, we all know that there was then, even more than now, a very strong organization of citizens who were saying, hey, we don't like this kind of stuff. We're flexing our muscles. We're getting things done. And you might not know, but does it seem credible that all of those people go, oh, I think I need to take a nap. I'm not interested. Really?
I don't know, Dale. That I do not know the history in that respect. I wondered about that, but the law is clear of what notice requires. See, from what I gather, somebody was contesting that fee. Somebody argued that the fee was counter to the charter, and by that I mean the fee that kicked off this whole controversy, the fee for the public lands. Get that right.
What was the idea that they were going to impose this fee
Public land
without
corner
taking it
preservation
to the
fund.
people? Because otherwise it looks like a setup. Sorry, but it does.
I don't know. I don't know. I don't know the answer to that. I mean, it seems that based upon the affidavit, let me see if I can find, and this is really what I have to go on. I mean, it says, basically that it was a contested question involving political. It was a political controversy, basically, is what he says. I'm paraphrasing there, but basically it sounded like there was a political controversy, that it sounded like there was somebody who was arguing that this public land preservation fee was not valid pursuant to the charter. And that's how this thing wound up being sought declaratory judgment.
We don't know who or why.
I don't.
Well, it's not beyond the possibilities, not asking for you to speculate, that someone could have sort of said, you know, I hear you, commissioners or legal counsel or whoever, and so I'll file on this, even though it may be following the charter, you know, and that will lead to a court case. I mean, look at the results. It's pretty convenient. So what we have to believe then in this is that people who are getting what they asked for appeal something which puts the whole thing up in the air, and then they don't care enough to show up in court to challenge it. Really, that's quite a big risk. And it's irresponsible. Really? Everybody was irresponsible?
I know what's in here. That is what I know. I can say there is a copy of the notice at least. So, and the judge was satisfied that the statutory requirements for notice were put out. How the whole thing got kicked off, I wonder about. The result, in any event, I don't. So, on 21 September 2005, Circuit Court Judge Alan Kuhn entered an order of default, and he does state it is hereby order and a judge, the Josephine County, a political subdivision, and all electors, freeholders, taxpayers, and other interested persons whomsoever are in default, and that the default is entered of record. So again, that's 1st September 2005. And then that was on 1st of September 2005. And then on 21 September, he filed the judgment of validation. This was from Judge Kuhn. He says, among other things, he says that the public land corner preservation fees are proper and valid, and that the Board of County Commissioners acted within its authority in so doing. He says no error, irregularity, or omission in the proceedings establishing the fees to be collected for the Public Land Corner Preservation Fund affects substantive rights of the parties to this proceeding. And he states, finally, the Board of County Commissioners have judgment validating the actions of the Board in creating the process to collect fees under the applicable statute, ORS 203-148. Validating the process. So the court has so decided.
So then what was the result regarding the charter itself? The whole amendment was wiped out?
It was not. The whole amendment, from my reading, is still in force. But remember, the amendment states, voter approval shall be required. In other words, the judge is saying the voters approved this. Because remember, it went back to the voters in the form of that ballot measure that basically the voters were asked, is it okay to establish a process by which the commissioners, through public hearings, can establish and raise fees?
Well, that's a little confusing because they establish fees all the time now, and I don't see any voters approving it.
The legal argument is that the voters did approve this because the voters approved it. We'll return to this concept, this subject of Measure 1773.
Right.
Okay, so the charter says voter approval shall be required. So then the voters considered Measure 1773.
Which was only about corner preservation.
No.
I'm sorry, I got that wrong.
Yeah, that was the fee procedure.
Okay.
You know what I mean? So
Yeah.
that was, yeah. And it says in here, among other things, the county charter requires voter approval before any use fee, et cetera, et cetera. And then it says there's going to be a fee procedure. And so when you connect up this requirement of the charter for voter approval with this measure that the voters actually approved, the judge analyzed it and said, yes, the procedure is lawful.
So it sounds like what happened is that the public, somebody in the public, had an amendment that required every time the commissioners want to raise a fee,
Yes.
or probably they put them all together, not, once a week, but
Yeah.
every time they want to increase fees, that they would need to put it on the ballot so that people could say yes. And then somebody came up with the bright idea of saying, well, let's establish a procedure where that will essentially be nullified. And now we just have a procedure for doing it, and it's back in the hands of the commissioners.
It is, the procedure is the law of the land. That is the way that it's being.
It's back in the hands of the commissioners. It's not in the hands of the people any longer. According to that.
I mean, yeah. In terms of the routine establishment and
Why would they do
increases-
that? They had it in their hands and they gave it away?
I don't know, Dale, but that is what has occurred, and so the voters have spoken on the matter.
That seems like a mystery. Here they had all that power, and now they no longer do. And is it still in effect that it has to be justifiable, whatever the fee is? For example, when
I
you
think it
gave us, Mike and I here, when you gave us this document of 33 pages, we're gonna have to spend 25 cents per page.
Yes.
And a research fee to the office staff for not doing any research on this, basically. But now, But it doesn't cost 25 cents a page to make copies anywhere in the universe except, I don't know, Hong Kong or something. It doesn't cost that much. So doesn't it have to be justifiable? Isn't that even state law that if you're going to charge a fee, it has to be justifiable? That's not justifiable. I mean, even Staples, you go down there and you can get a deal for 5 or 6 pay, and they're a for-profit company. Not only do they have people working there and overhead and lights and all the rest of that, but then they have to establish a fee, but they're not going to lose money on it. Even they're 5 or 6 cents a copy, and our cost for doing this is 25 cents every page, and the taxpayers buy the paper and the toner and pay the people their salaries. And in addition to that, it's now 25 cents? How can that be possible if it's based on actual cost?
Is it lawful or not? Is that what you're asking?
Well,
If you think the fee's too high, then, I mean, you have your recourse, I suppose, but
Well, yeah, but everybody knows we don't have 2 nickels to rub together. The populace doesn't. I mean, all they've got is the ballot, and then they try to do this thing saying, hey, let's be reasonable about this, and then suddenly it sort of all gets shunted off to the side twice. First, a bunch of people get together who knows who they were and then put it back in the hands of the commissioners. Well, you're best to decide these kinds of things. Yeah, well, we'll decide 25 cents. And then the whole thing is set aside because nobody cared to do anything about it. Some of this stretches credibility.
whose?
Well, the idea that nobody would care enough to show up.
I never said that, did I?
Oh, brother.
I said I don't know why no one showed up.
No. So, let's suppose that, and appreciate this, let's suppose that people wish to say, look, we don't like something. If it's not today, it might be something tomorrow about fees, and we'd like to do something about it. Is the only alternative to bring another initiative, to have another initiative signed and bring it to the ballot again? You've often talked, let me put it another way, you've often talked about how there may be some things in the charter that need to be fixed or made more clear or more or closer to the intention of the original people or whatever. What's the remedy, if one is needed, in this particular case?
What are your options?
Okay?
I think that the law was changed by, in this case, just a vote of the people, a simple majority of the people. It was placed there, it was placed there by the Board of Commissioners. And so either the board can put out a ballot measure.
Oh, the board put that out?
I think
That
so,
was
yeah.
not brought out by the people?
I think it was put out by, it says furnished by the Josephine County Board of Commissioners.
That's interesting. They put it on the ballot.
I think
And
that's
it
right.
costs them nothing to do that, and they don't have to gather any signatures to do that.
I think that's accurate, yes. I think that they did put that on the ballot, yes. That is not, of course, the only way to get something on the ballot. Of course, as you've indicated, gathering signatures, filing a petition, that's another way of doing
It
it.
takes a lot of effort. That's how the amendment got passed. That amendment wasn't passed by Board of County Commissioners putting something on the ballot for free.
No amendment can be for the.
Right.